The compliance briefing stated that legal counsel had approved the data sharing arrangement. The board's outside attorney had my memo explicitly recommending against the arrangement due to regulatory violations. I'd been working as a compliance analyst for a remote fintech company headquartered in Dallas for 2 years. I reviewed regulatory requirements, I assessed legal risk, I drafted compliance recommendations for executive decisions. The data sharing partnership with the third-party marketing firm had been proposed in March. I'd reviewed the arrangement against federal privacy regulations. I'd identified 3 clear violations of consumer data protection laws. My legal memo was dated March 28th. Conclusion. The proposed data sharing arrangement violates CFPB regulations 1002.14a and 1002.15b. Recommendation. Do not proceed without substantial modification to data handling protocols or explicit written consent from affected consumers. The compliance briefing to leadership was dated April 15th. It stated, Legal counsel has reviewed the data sharing arrangement and confirmed compliance with applicable regulations. Approved to proceed. I hadn't approved anything. I'd explicitly recommended against proceeding. The board's outside attorney had requested a copy of all compliance documentation in May. I provided my original memo. The attorney had forwarded it to the board with a note, "This memo clearly states the arrangement violates federal regulations. Please clarify why the April briefing indicates legal approval." My name is Samantha. I analysed regulatory compliance for financial services. I interpreted consumer protection laws. I documented legal risk for business decisions. I'd been doing this work for 6 years. I'd never had a compliance recommendation misrepresented before. Someone had told leadership I'd approved a violation I'd actually flagged as illegal. I opened my compliance file and started reviewing what had been changed. My March 28th memo had been clear and unambiguous. 3 specific regulatory violations. Explicit recommendation not to proceed. Violation 1. The proposed data sharing transferred consumer financial information to a third party without express written consent. CFPB Regulation 1002.14a required documented consumer authorization for such transfers. Violation 2. The third-party marketing firm would use the data for credit-related marketing. CFPB Regulation 1002.15b prohibited sharing consumer data for marketing purposes without opt-in consent. Violation 3. The data sharing agreement lacked adequate security and breach notification provisions required under federal consumer protection standards. Each violation carried potential fines of $5,000 to $25,000 per affected consumer. We had 47,000 consumers in our database. The regulatory exposure was substantial. My memo had concluded with specific recommendations. Obtain explicit written consent, revise the data handling protocols, or abandon the arrangement entirely. The April 15th compliance briefing had stated the opposite. It claimed legal counsel had approved the arrangement. I reviewed the briefing document. It was authored by the Director of Business Development. Not by me, not by our legal team, not by compliance. The director had written the briefing and attributed a legal approval that didn't exist. I checked my email records. I'd never been asked to approve the arrangement. I'd never been consulted about the April briefing. I'd only learned about it when the board's outside attorney had requested my compliance documentation in May. I documented the timeline and saved everything. My original memo, the false briefing, the board attorney's inquiry. My response providing the actual legal analysis. Then I continued my normal compliance work and waited. I didn't immediately correct the false briefing. I didn't email the director or leadership. I just maintained my regular review schedule and documented. 4 days after providing my memo to the board attorney, I received an email from the CFO. Subject line: Compliance Review Meeting. The meeting was scheduled for May 20th. The CFO, the Director of Business Development, and me. I accepted the meeting and prepared copies of my March memo. The May 20th meeting was held via video conference. The CFO opened the conversation. The board has raised questions about the data sharing partnership. They've seen conflicting information about the compliance review. I waited. The April briefing indicated legal approval. The board's attorney received a memo stating the arrangement violates regulations. Can you clarify? My March 28th memo identified 3 regulatory violations and recommended against proceeding. I provided that memo to the board attorney when requested.
The Director of Business Development interrupted. Your initial review raised some concerns, but we addressed those through modifications to the arrangement. What modifications? I asked. We implemented additional security protocols. Security protocols don't address the consumer consent requirements under CFPB Regulations 1002.14 and 1002.15. Those violations require either explicit written consent from each consumer or fundamental changes to how data is shared. The CFO made notes. Did you review any modified arrangement? No, I was never asked to review modifications or provide updated compliance analysis. The CFO looked at the director. The April briefing states that legal counsel approved the arrangement. Which counsel provided that approval? The director hesitated. The compliance analysis indicated the partnership could proceed with appropriate safeguards. My analysis recommended against proceeding, I said. I can provide the complete memo. I shared my March 28th memo on screen. The CFO read it carefully. This explicitly states the arrangement violates federal regulations. Correct. 3 specific violations with substantial regulatory exposure. And you never approved any modified version? No. I was never consulted about modifications or asked for updated analysis. The CFO closed the meeting without resolution. I documented the conversation and returned to my work. 2 days later, I received an email from the board secretary. The board was requesting all compliance documentation related to the data sharing partnership. They wanted my complete file by May 25th. I compiled everything. My original March memo, all regulatory citations, my analysis of each violation, email record showing I'd never been consulted about the April briefing or any modifications. I submitted the complete package on May 24th. I also noted that I'd never been copied on communications about the partnership after submitting my March memo. Someone had deliberately excluded me from the decision process. 1 week passed. On June 1st, the CEO sent a company-wide email. The data sharing partnership was being terminated immediately. No explanation provided. I saved the announcement and continued my compliance reviews. 3 days later, on June 4th, I received a meeting invitation from the board chair. The board chair, the CEO, and me, scheduled for June 8th. I accepted and prepared my complete documentation. The June 8th meeting was direct. The board has reviewed your compliance memo and the April briefing, the board chair said. We need to understand how a compliance analysis explicitly recommending against a partnership became a briefing stating legal approval. I provided a factual summary. My March 28th memo identifying violations, the April 15th briefing claiming approval, my lack of involvement in creating or reviewing the briefing. Who authored the April briefing? The Director of Business Development. Did he consult with you before stating that legal counsel had approved the arrangement? No. I was never contacted about the briefing or asked to review it before distribution. The board chair looked at the CEO. Why was the compliance analyst excluded from communications about a partnership she'd flagged for regulatory violations? The CEO appeared uncomfortable. The business development team was managing the partnership discussions. They believed they'd addressed the compliance concerns by implementing security protocols. That was their understanding. Security protocols don't address consent requirements, I said. The violations I identified require consumer authorization, not technical safeguards. The board chair made extensive notes. We're going to conduct a comprehensive review of this situation. Samantha, please provide the board with any additional documentation you have regarding compliance communications and processes. The meeting ended. I compiled every compliance memo I'd written over the past 2 years, every regulatory analysis, every recommendation, every response from business teams. I submitted the package to the board on June 10th. 2 weeks later, on June 24th, the Director of Business Development announced his resignation, effective immediately. Pursuing other opportunities. I documented the announcement and maintained my regular work. On June 28th, the board chair sent another meeting invitation, just the two of us, scheduled for July 1st. The July 1st meeting was focused and brief. The board has completed its review, the board chair said. Your compliance work has been thorough and accurate. The April briefing misrepresented your analysis. I nodded. We're implementing new compliance governance protocols. All compliance recommendations will be distributed directly to the board. Business teams cannot summarize or recharacterize legal analysis without compliance review. That will prevent similar misrepresentations. We're also creating a direct reporting line from compliance to the board for regulatory matters. You'll maintain your current role, but with board oversight for significant compliance issues. What about the data sharing partnership that was terminated? We reported the potential violations to the CFPB voluntarily, because we terminated before implementing the data sharing and because we self-reported. They issued a warning letter, but no fines. And if we'd proceeded based on the false April briefing, we would have faced substantial penalties. Your March memo prevented that outcome, even though it was initially ignored. I accepted the new reporting structure. The compliance governance protocols were implemented in July. All regulatory memos were distributed directly to board members. Business teams could no longer create compliance briefings without sign-off from the compliance function. I spent August developing new documentation standards. Every compliance review included explicit approval or rejection language. Every recommendation specified required actions and regulatory consequences. By September, we'd reviewed 12 new business initiatives using the updated protocols. 3 were modified based on compliance requirements, 2 were abandoned due to regulatory conflicts, none proceeded with false claims of legal approval. 6 months after the data-sharing partnership was terminated, I was promoted to Senior Compliance Analyst. The role included direct board access and authority to halt business initiatives pending regulatory review. A year after the false April briefing, I was managing compliance operations for the entire company. I reported to the board quarterly on regulatory risk and business compliance. 2 years later, I was Director of Compliance and Regulatory Affairs. I managed a team of 4 analysts. We reviewed every significant business partnership and product launch for regulatory compliance. None of our compliance recommendations were misrepresented to leadership again. 3 years after the March 28th memo that had been falsely characterized as approval, I still had all the documentation. My original analysis stating the arrangement violated federal law. The April briefing claiming I'd approved it. The board attorney's inquiry that had exposed the discrepancy. Those documents had shown what happened when someone rewrote a compliance recommendation to say what business teams wanted instead of what regulations required. The board had reviewed both versions and reached their own conclusions. The false briefing had been withdrawn. The partnership had been terminated. The director who'd authored the misrepresentation was gone. Everything after that had been about building systems that prevented compliance analysis from being altered or summarized by people who didn't understand that regulatory recommendations weren't negotiable. The director of business development had thought he could change my no into an approval by writing a briefing that claimed legal counsel had blessed the arrangement. The board attorney's request for my actual memo had made that impossible, because once the board saw what I'd actually written, the contradiction between my analysis and his briefing was too clear to ignore. That hadn't stopped the initial misrepresentation or prevented the partnership from being proposed, but it had established that compliance recommendations existed in writing, and that anyone claiming legal approval when none had been given would eventually be contradicted by the documents that showed what had actually been said. The new governance protocols ensured the board saw those documents directly, which meant no one could rewrite regulatory analysis to support business initiatives that violated federal law. That was a simpler system than hoping business teams would accurately represent compliance advice they didn't want to follow.